HOA Karen sold 96 lots on my inherited land, then told me I could be sued for delaying homes that were never hers to sell. I found out on a quiet Saturday morning when I drove to my father's old 42 acres and saw orange survey flags, numbered stakes, a glossy Cedar Hollow phasey sign, and a QR code advertising home sites across my field. One of them, Lot 37, was marked reserved under the oak tree where my late wife wanted to plant pecans. Karen Mills stood at the gate in a cream blazer with a clipboard, smiling like the board had already erased my family as deed. She said, the expansion was approved, the buyers were waiting, and if I interfered, damages could get expensive. I didn't yell. I didn't touch a stake. I asked for the county recording number. Karen laughed and told me to prove it in a way that matters. So I went home and opened my father's deed box, because one county record inside was about to turn her entire phase into evidence. My name is William Thomas Whitaker, but everybody who knows me calls me Tom. I am 67 years old, retired, and I have spent most of my life believing that a man does not need much as long as he has his name, his family, and a piece of ground nobody can take from him. My father believed that more than anyone I ever knew. Earl Whitaker bought 42 acres outside Cedar Hollow in 1971, back when that part of the county was still pine trees, red clay, deer tracks, and two-lane roads with no streetlights. He never called it an investment. He called it breathing room. When developers started circling in the late 80s, he turned them away from the kitchen table, one by one. When Cedar Hollow Estates was built on the neighboring tract, years later, he walked the boundary with me and tapped every iron pin with the toe of his boot. Remember this line, he told me. People don't always steal land with guns. Sometimes they steal it with paper. My father was not an educated man in the way lawyers use that word, but he understood land better than most men understand their own names. He knew where the soil turned sandy near the creek. He knew which pine had been split by lightning in 1983. He knew which corner marker disappeared under leaves every fall. To him, that land was not empty space waiting for a builder. It was memory. It was work. It was proof that a man could leave something honest behind. After he passed, the land came to me. The deed had my full name on it, William Thomas Whitaker. I paid the taxes every year. I kept the receipts in the same gray metal box where my father kept the old survey, his handwritten notes, and the original deed that still smelled faintly like dust and pipe tobacco. My wife, Margaret, loved that land. She used to talk about planting pecan trees near the old oak and building a little walking trail for the grandkids. After she died, I stopped going out there as often. Not because I stopped caring. Because every time I saw that oak tree, I could hear her voice. So that Saturday morning, I almost did not go. A storm had rolled through the night before, and I wanted to check the fence line. I put coffee in a travel mug, climbed into my old Ford, and drove the back road toward the Whitaker parcel. The sky was low and gray. The kind of morning where everything feels quiet enough to hear your own thoughts. Then I turned past the drainage ditch and saw orange flags. At first, I thought the county had marked utilities. Then I saw wooden stakes hammered into the ground, each one sprayed with black numbers. Lot 12. Lot 19. Lot 31. I slowed the truck until gravel cracked under the tires. A temporary sign had been planted beside my father's old cattle gate. It was glossy, expensive looking, with a computer rendering of beige houses, curved sidewalks, and smiling families walking dogs. Cedar Hollow Estates. Phase IEA. 96 premium home sites coming soon. For a few seconds, I just sat there with both hands on the steering wheel. My father's old sign was still nailed to the post beside it. Whitaker Land Private Property. Someone had zip-tied another sign underneath it. HOA Development Access Do Not Block. That was the first moment I felt my stomach go cold. I got out, slowly. I did not shout. I did not pull up the stakes, even though every part of me wanted to. I walked past the gate and saw tire tracks pressed deep into the wet grass. Orange ribbon hung from saplings. Blue paint marked 2 pines near the old fence. And on the side of the big oak tree, the one Margaret loved, someone had sprayed a bright pink X. Then, I noticed more. A stack of PVC marker pipes lay beside the ditch. Someone had dragged a roll of erosion fencing across the grass and left muddy boot prints all the way to the oak. A small excavator sat near the tree line, bucket lowered into my soil, like a hand resting on something it planned to take. Fresh gravel had been dumped over the old wagon path my father used to drive his tractor down. Lurvey tape fluttered from branches that had never belonged to Cedar Hollow, each ribbon snapping in the wind like a little warning flag. That tree was not timber to me. It was where my father had carved his initials in 1974. It was where Margaret once tied a ribbon and said, "This is where the trail should start." I took out my phone and began recording. That was when the white SUV arrived. It rolled up behind my truck like it owned the road. The driver's door opened, and out stepped Karen Mills, president of the Cedar Hollow HOA. I knew her by sight. Cream blazer, pearl earrings, perfect hair, clipboard tucked under one arm. She had the expression of a woman who believed a rule became law the second she said it out loud. 2 board members got out behind her. A younger man in a navy vest followed, holding a folder with a real estate company logo on it. Karen smiled at me, like I was an inconvenience she had already scheduled time to remove. "Mr. Whitaker," she said, "I was wondering when you come by." I looked back at the flags scattered across my field. "What is this?" She tilted her head, as if I had asked something childish. "This is Cedar Hollow Phase I. The expansion has been in the community plan for years. This is my land." Her smile did not move. It was marked as future development before. Most of us moved here. The board has already approved the expansion. I stared at her clipboard, then at the stakes. The board can't approve land it does to own. One of the board members shifted uncomfortably, but Karen did not. She opened her folder and pulled out a colored map. Across the top in bold letters it said Future Phase D. A red line wrapped around the back acreage like someone had simply decided my father's land belonged inside their neighborhood. I pointed to the map. "What is the county recording number?" With Karen blinked. Sorry. The deed transfer, the recorded plat, the easement, the annexation amendment. Whatever you reclaiming, give Cedar Hollow authority over this parcel." "What is the recording number?" Her face tightened just a little. "You can take that up with the board attorney." "I am asking you." She lowered the paper. "Mr. Whitaker, we already have families reserving home sites. This kind of obstruction could cost people their homes." Behind her, the real estate man avoided my eyes. That word hit me strangely. Word obstruction. As if standing on my own father's land made me the problem. Karen looked past me toward the field. "We're not trying to be difficult, but progress does not stop because one holdout refuses to cooperate." I felt heat rise in my chest. I thought about my father tapping those iron pins. I thought about Margaret wanting pecan trees. I thought about that pink X on the oak. But I kept my voice even. "Well, show me the recorded document." Karen stepped closer, lowering her voice. "You should be careful, Tom. Once buyers are involved, damages get expensive." Then she lifted her phone and angled it toward my face. "I'm going to document this interaction. If you interfere with access, remove stakes, threaten workers, or harass prospective buyers, the HOA will pursue every remedy available." You may think this is still some old family field, but to 96 families, it is their future neighborhood. I looked at the camera lens, then back at her. "You are standing on private land." Karen smiled wider. "Then prove it in a way that matters." Then she turned to the younger man. "Make sure the preview link stays active." Preview link. I looked back at the glossy sign and noticed the QR code at the bottom. After Karen drove away, I stood alone at the gate with wet grass soaking the cuffs of my jeans. I opened my phone, scanned the code, and waited as the page loaded. Cedar Hollow Phased IV appeared on the screen. 96 lots. Interactive map. Reservation status. And there, under the old oak tree, was a blue square labeled Lot 37 reserved. That was when I stopped, thinking Karen had made a mistake. Because mistakes do not come with reservation numbers, I did not sleep much that night. Every time I closed my eyes, I saw that blue square on the website. Lot 37 reserved. It had sat right under the old oak tree, like somebody had taken a memory from my family and turned it into a product listing. Not a field. Not a piece of land my father worked and paid taxes on for half a century. A home site. A number. A future address for someone who had no idea they were standing inside another man's inheritance. By 6 the next morning, I had the gray metal deed box open on my kitchen table. My father had labeled everything in block letters. Billy, deed. Taxes. Ron, survey. While Cedar Hollow. He was not a sentimental man with words, but the way he kept paper told you what he loved. Every receipt was folded flat. Every envelope had dates written in pencil. There were property tax bills going back decades, copies of old survey maps, and a yellowed letter from 1998 where a developer offered to buy the back acreage. Across the bottom, my father had written one sentence. No sale, not now, not ever. I ran my hand over the words and felt something settle inside me. Karen Mills thought she had found an old man who would panic, shout, or sign whatever paper made the problem go away. While she had not known my father. At 9:14 a.m., the first certified letter came. The mail carrier knocked because it needed a signature. I saw the Cedar Hollow HOA return address before I even opened it. Raw, thick envelope. Cream paper. Official-looking seal at the top. Karen had wasted no time. The letter claimed I was interfering with an approved community expansion. It said my private property signs created confusion for prospective homeowners. It said the HOA had a legal interest in planned development access. It ordered me to remove all obstruction from Phase 5 within 72 hours. Then came the part meant to scare me. Failure to comply may result in legal action, recovery of administrative costs, attorney fees, and damages caused by delay of buyer reservations. I read that sentence 3 times. Damages caused by delay. She had walked onto my land, marked my trees, advertised 96 lots, and now she wanted me to believe I might owe her money for getting in her way. I called the number at the bottom of the letter. The woman at the HOA management office answered. When I gave her my name, her voice changed. "Oh, Mr. Whitaker, Mrs. Mills said you might call. I need the recorded document that gives Cedar Hollow authority over my parcel." A pause. "You would need to attend the board review for that." "No, I need the record now." Deed book, page number, instrument number, recorded easement, annexation amendment. Really, any of those. Another pause. Papers. Shuffled. "Sir, I'm not authorized to provide legal interpretation." "I'm not asking for interpretation. I'm asking for the document." Her voice got smaller. "We'll have someone call you back." No one did. By noon, I drove back to the gate. This time, I did not go alone. My daughter Emily insisted on coming with me. She is 41, a high school history teacher, and has her grandfather's way of looking at foolishness, like it is something that needs to be corrected with a red pen. When we turned off the road, there were 3 cars parked near the entrance. Karen was there again, standing beside the glossy Phased I sign. This time, she had an audience. 2 couples, a man in a blue sport coat, and a young family with a little boy holding a toy bulldozer. Karen was pointing across my land like a tour guide. "Lot sizes start at just under half an acre," she said, "and the oak preserve will become a shared green space. Emily whispered, "Oak Preserve." I gripped the steering wheel. "That is your grandmother's tree." We got out. Karen saw us and lifted her chin. "Mr. Whitaker, this is not a good time." I looked at the people gathered around her. "It looks like the perfect time." The man in the blue sport coat stepped forward with a salesman-esque smile. "Priest and Vale. Vale Residential Group. We repartnering with Cedar Hollow on the expansion." He held out his hand. I did not take it. "Are you the one selling lots on my land?" The smile tightened. "We re-offering reservation opportunities pending final approvals." "That is not what your sign says." Layer Ken stepped between us. "Tom, you re-upsetting buyers." I'm asking who took their money." The young couple looked at each other. The woman held a folder against her chest, while Karen turned to them quickly. "There is no need to engage with him. This is a boundary misunderstanding that will be resolved." Emily laughed once, not because it was funny. "A boundary misunderstanding with 96 lot numbers?" Karen's eyes moved to my daughter. "And you are." Emily Whitaker, his daughter, also someone who can read a deed. That wiped the smile off Karen's face for half a second. The young woman with the folder stepped closer. She had tired eyes and the cautious expression of someone who had already put hope into something expensive. "Excuse me," she said. "Are you saying this land is not part of Cedar Hollow?" I looked at her, and my anger shifted. Because she was not Karen. She was not Prieston. She was a person who had probably saved money, checked school ratings, imagined furniture in rooms that did not exist yet. "What's your name?" I asked. "Jenna Ellis. This is my husband, Mark." Mark nodded, holding the little boy's hand. "We reserved lot 37, Jenna said." Emily went still beside me. "Lot 37. The oak tree." I kept my voice steady. "May I see your paperwork?" Karen snapped, "Absolutely not. Private purchase documents are not his business." But Jenna was already opening the folder. "I want to know," she said. She handed me the top page. It was printed on thick paper, with the Cedar Hollow logo in one corner and Vale Residential Group in the other. Reservation Agreement, Cedar Hollow Estates, Phase Z. Lot 37. Deposit received, $5,000. At the bottom were two signatures. Karen Mills, HOA President. Preston Vale, Managing Member. My fingers tightened around the page. Then, I saw the sentence in small print near the middle. Subject to final title clearance and municipal approval. There it was. Not final title cleared. Not land acquired. Not legally transferred. It was subject to. I looked at Preston. "You took $5,000 from this family for a lot you do not have title to." Preston raised both hands in a polished, harmless way. "That is standard language in development reservations." "Then why did your sign say home sites coming soon?" While Karen cut in. "Because they are coming soon, if you stop obstructing." I looked at Jenna and Mark. "Before you pay another dollar, ask them for the recorded deed that includes this land." For Karen's face hardened. "That is enough." While she lifted her phone and started recording. "Mr. Whitaker is now interfering with prospective buyers and making false claims about a lawful development." Emily stepped forward. "Careful, Karen. You re-recording yourself standing on posted private property." Karen smiled into her phone. "Private property is exactly what we are trying to clarify." That was when the little boy pointed toward the field and asked his father, "Is that where our house goes?" Nobody answered him. For the first time that day, Karen looked uncomfortable. Then a sheriff's cruiser turned off the road. Deputy Alan Reeves got out slowly, one hand resting near his belt but not on his weapon. He looked at the sign, the orange flags, Karen S. phone, then me. Who called? While Karen raised her hand. I did. This man is disrupting an approved HOA development event. I said, this is my land, they reselling lots on it. Deputy Reeves looked like a man who had just been handed a headache before lunch. What, does anyone have paperwork? Karen lifted her packet immediately. The board-approved Phase ID. I handed him my driver's license and a copy of the tax bill I had printed that morning. This parcel is in my name. I can get the deed, survey, and county record. The deputy looked over both stacks, then exhaled. I'm not making a land ownership decision from the side of a road. Karen started to speak, but he raised a hand. What I can say is this: I'm not here to enforce HOA expansion plans. If ownership is disputed, that's civil. But if the property is posted and someone damages it or refuses to leave after being warned, that may be a different report. Karen's mouth opened, then closed. The buyers were listening now. Deputy Reeves turned to me. Mr. Whitaker, I suggest you gather your records and speak to an attorney. Then he looked at Karen. I suggest nobody moves equipment farther onto this parcel until someone can show clear authority. It was not a victory. Not yet. But it was the first time all morning Karen had stopped smiling. After the deputy left, Jenna quietly asked me if she could take a picture of the tax bill. I let her. Karen watched, like I had stolen something from her instead of showing a family the truth. Before I left, I walked back to the glossy sign and took one more photo of the QR code. While Karen came up beside me. You are making a mistake, she said quietly. These people want homes. The board wants this finished. The developer has attorneys. You are one retired man with an old field. I looked at the pink X on Margaret S. Oak. No, I said, I am one retired man with records. That night, I spread Jenna's reservation agreement across my kitchen table beside my father's deed box. While Emily sat across from me, reading the fine print with a yellow highlighter. Then she stopped. What, Dad? I looked up. She turned the page around and pointed to a paragraph under the developer as disclosure. Seller makes no warranty that final title has been obtained as of the date of reservation. For a moment, the kitchen was completely silent. Karen had not made a mistake. Preston had not made a mistake. They had put the warning in writing, collected the money anyway, and counted on nobody asking the one question my father taught me to ask. Who owns the land? And by the time I closed the deed box that night, I knew this was no longer about orange flags. It was about 96 families, $5,000 deposits, and a lie dressed up as a neighborhood. The next morning, I drove to the county recorder's office with my father's gray metal deed box sitting on the passenger seat like a witness. It was 8:12 a.m., and the building still smelled like floor polish and old paper. I had not been inside that office since my father died, but I remembered the place from childhood. He used to bring me there when he paid fees, checked plats, or argued with clerks who tried to tell him a copy was good enough. Never trust a copy if the original still exists, he would say. I carried the box under one arm and Karen S. Phase I packet under the other. The woman behind the counter looked up over her glasses. Ranch, can I help you? I need the full record history for parcel 14 Whitaker land, west of Cedar Hollow Estates. Her expression changed when she heard the name. Whitaker, she repeated. Earl Whitaker? My father. Lime, she softened a little. I remember him. He came in every few years just to make sure nothing strange had been filed. That hit me harder than I expected. Even years before Karen Mills ever put a flag in my field, my father had been watching the paper trail. He had known that land could disappear one document at a time if a family stopped paying attention. The clerk's name was Donna. She led me to a public records terminal and began pulling the parcel history. First came the current owner page. William Thomas Whitaker. Then, the parcel map. 42 acres. Then the deed chain, going backward from me to my father, Earl Whitaker, all the way to the purchase in 1971. No transfer to Cedar Hollow. No sale to Vale Residential Group. No deed into the HOA. No annexation amendment. No development easement. Donna printed each page and stamped the top with the county certification seal. I set Karen's glossy map beside the official parcel map. Hers showed the red phase nigh-by boundary wrapping around my land. The county map showed something completely different. Cedar Hollow stopped at the drainage ditch, just like my father had always said. A glossy brochure had stolen the boundary. The county record put it back. Donna frowned at the Phase the E packet. Where did you get this? Karen Mills handed it to buyers. She turned a page and stopped at the old concept map. Oh, she said quietly, I know this one. You do? Oh, she called over a man from the mapping department. He was thin, gray-haired, with a coffee mug that said measure twice, sue once. This is Caleb Price, Donna said. He has been here longer than the carpet. Caleb took one look at Karen's map and shook his head. That plan was never approved. My mouth went dry. Can you prove that? They gave me the kind of look my father used to give when someone asked if rain was wet. Follow me. We went to a back counter where Caleb pulled up archived planning records. After a few minutes of typing, he found a scanned document from 2006, Preliminary Concept Plan, Cedar Hollow Future Phase 90. Across the first page was a county stamp. Rejected incomplete ownership control. While Caleb printed the file and pointed to a note near the bottom. Phase I cannot proceed without acquisition of Whitaker parcel. For a moment, I could not speak. There it was. Not hidden in legal language. Not buried under 100 pages of fine print. One sentence. They had known, years ago, that Cedar Hollow could not expand onto my land unless my family sold it. And my father never had. Caleb leaned against the counter. The original developer tried to buy that tract Earl wouldn't sell. After that, Phase My died. Somebody using that old map now is either careless or hoping nobody checks the county file. I looked down at Karen's brochure, which she is collecting deposits. Caleb's face changed. Then, you need a lawyer. I already knew that. But hearing it inside the county office, with the certified records warm from the printer, made the whole thing feel less like a neighborhood dispute and more like a trap that had almost closed around me. Before I left, Donna printed the tax record. Paid. Every year. My father. Then, me. Decades of small, boring proof. To Karen, maybe it looked like nothing. To me, it looked like a shield. From the parking lot, I called the title company listed in Jenna Ellis's reservation packet. After 2 transfers and 8 minutes of hold music, I reached a woman named Marisa Holt. I explained who I was. There was a pause on the line. Mr. Whitaker, she said carefully, I can discuss private client matters in detail. I understand, but your company's name appears in a packet being given to buyers for lots on my land. Another pause. This one was longer. Then she said, our office declined to issue title insurance for the proposed phase lots. I closed my eyes. Why? Because the submitted documents did not establish ownership or development authority over the parcel. Did you tell them that? What? Yes. Like, in writing? Yes. The word landed like a nail through wood. Karen and Preston had not been waiting for title clearance. They had been warned there was no title clearance. And they kept selling reservations anyway. Marisa lowered her voice. If your attorney contacts us properly, we can respond through the appropriate channels. That was all she would say, but it was enough. My next call was to an attorney named Lydia Mercer. She was not cheap, and she did not sound impressed by panic. She listened for almost 20 minutes while I explained the flags, the QR code, the buyers, the HOA letter, the sheriff, the county records, and the title company. When I finished, she asked one question. Do you still have the original deed? Yes. Tax receipts? Yes. Photos of the stakes and signage? Yes. Buyer paperwork? Yes. Good, she said. Then stop talking to Karen Mills directly. That was the first thing she told me. The second was not to post anything online, not to argue with neighbors, not to pull up the stakes, and not to threaten anyone. People like Karen want you emotional, Lydia said. They want one bad sentence from you they can use to make this look like a personal feud. We are going to keep it about records. I drove straight to her office. Lydia Mercer was in her early 60s, with silver hair cut just below her chin and a voice so calm it made other people sound reckless. Her office had no dramatic decorations, no giant law books for show, just organized files, a scanner, and a framed survey map on the wall. She laid my documents across the conference table in rows. A deed, tax receipts, county parcel map, recorded Cedar Hollow plat, rejected phase D fee plan, HO, a letter, buyer reservation agreement, photos. She studied the reservation receipt the longest. $5,000 per lot, she said. At least one couple paid that. If they offered 96 lots, this could be hundreds of thousands in deposits. My stomach tightened. I don't want those families hurt. While Lydia looked up. Then, we separate the victims from the people who created the problem. That sentence stayed with me. Because until then, I had been angry at everyone standing in my field. But Jenna and Mark Ellis had not stolen anything from me. They had been sold a dream with someone else's boundary line wrapped around it. Lydia tapped the phase ID map. This is not enough to transfer land. This is a concept drawing. It has no legal power by itself. Then she tapped the rejected county note. This is what matters. Phase cannot proceed without acquisition of Whitaker parcel. She made 3 copies. 1 for her file. 1 for the demand letter. 1 for court. Then she asked for the HOA meeting minutes. I don't need to have them. You will request them in writing today. Well, so I did. I emailed the Cedar Hollow Management Office asking for all board minutes, motions, votes, resolutions, and approvals relating to Phase Dike, land acquisition, development access, buyer reservations, and agreements with Vale Residential Group. Karen answered 47 minutes later. The board has already approved Phase. Your continued interference is being documented. No minutes. No motion. No vote count. No recording number. Just pressure. That evening, my phone rang from a number I did not recognize. Mr. Whitaker? A woman asked. This is Ruth Danner. I used to be secretary for the Cedar Hollow board. I sat down slowly. Yes, ma'am. I saw what Karen is doing. I can stay quiet. She told me there had been no valid vote. Karen had talked about Phase 9 in executive session, but the board never approved selling lots, collecting deposits, or claiming the Whitaker parcel. There had not even been a quorum the night Karen claimed the decision was made. I kept copies of the draft minutes, Ruth said. Karen told me not to include the discussion because it would confuse homeowners. That's when I resigned. I wrote that sentence down word for word. When I sent Lydia the notes, she called me back within 5 minutes. Now we have the spine of the case, she said. The spine? Your deed proves ownership. The county record proves the boundary. The rejected plat proves they knew acquisition was required. The title company warning proves they were told not to rely on the lots. And Ruth proves Karen's board approval may not exist. For the first time since I saw the orange flags, I felt something other than anger. I felt the ground under my feet again. That night, I put my father's deed back in the gray metal box, but I did not close the lid right away. I looked at his handwriting on the old envelope. No sale, not now, not ever. Then my phone buzzed. It was a screenshot from Jenna Ellis. Karen had scheduled an emergency buyer meeting for Friday night at the Cedar Hollow clubhouse. The message said, "Mr. Whitaker's false claims will be addressed publicly." I stared at that sentence for a long time. Karen thought she was bringing me into a room full of angry buyers. While she had no idea I was bringing the deed, the rejected plat, the title warning, and the woman who knew there had never been a vote. By Friday evening, the Cedar Hollow clubhouse parking lot was full. I had been there once before, years earlier, when Margaret dragged me to a community craft fair because one of her friends was selling homemade candles. Back then, the place smelled like coffee, cinnamon, and old carpet. That night, it smelled like raincoats, anger, and nervous people. Cars lined both sides of the street. Porch lights glowed across the neighborhood. Through the clubhouse windows, I could see rows of folding chairs packed with buyers, homeowners, board members, and people who had come just to watch a fight. Emily drove me there because she said my hands were too tight on the wheel. "You don't have to prove everything at once," she told me. I looked down at the folder in my lap. Yes, I do. Inside that folder were certified county records, the rejected Phase I plat, my father's deed, tax receipts, the buyer reservation agreement, and Ruth Danner's written statement. Lydia Mercer met us at the entrance. She wore a dark blue suit and carried a slim black binder. Not dramatic. Not flashy. Ranch, just prepared. "Remember," she said, "we are not here to win a shouting match. We are here to let records speak." Inside, the room went quiet when I walked in. Not respectful quiet. Suspicious quiet. People turned in their chairs. Some whispered. One man near the back shook his head, like he had already decided what kind of person I was. Jenna and Mark Ellis sat near the middle with their little boy between them. Jenna saw me, then looked down at the folder in her lap. At the front of the room stood Karen Mills. Cream blazer, pearl earrings, perfect hair, clipboard in hand. Beside her was Preston Vale in a charcoal suit, smiling like the kind of man who used confidence as a curtain. 2 HOA board members sat behind them. Neither one looked comfortable. While Karen tapped the microphone. "Thank you all for coming on short notice. I know many of you have concerns about misinformation being spread regarding Cedar Hollow Phase I. Misinformation. That was the word she chose for my father's deed. As she clicked a remote, and a slide appeared on the screen behind her. Cedar Hollow Phase D Community Growth Update. This expansion has been part of Cedar Hollow's long-term plan for many years, Karen said. Unfortunately, one individual has attempted to interfere with that progress by making unsupported claims about land ownership. Several heads turned toward me. I felt Emily stiffen beside me. With Karen, continued. Families have invested emotionally and financially in this future community. We will not allow intimidation or confusion to derail homes that have been promised in good faith. A few people clapped. Not many, but enough to make the room feel colder. Then Preston stepped forward. "Let me assure everyone," he said, "Vale Residential Group has followed standard development procedures. Reservation agreements are common at this stage. Final approvals take time. That does not mean there is wrongdoing." He smiled at the crowd. "These delays are unfortunate, but we are confident they will be resolved." Karen looked directly at me. "Mr. Whitaker has been invited tonight so he can hear the facts publicly." Lydia leaned toward me. "Now." I stood. The room shifted again. Chairs creaked. Someone whispered, "That's him." I walked to the front, slowly. Not because I was fearless. Because my knees needed the extra time. Warren did not move away from the microphone. This is not an open debate, she said. No, Lydia said from behind me. It is a meeting about land that your organization has advertised for sale. My client will make a brief statement. Karen S.'s smile froze. And you are? Lydia Mercer, counsel for William Thomas Whitaker. That changed the room. Not completely, but enough. Preston S.'s smile thinned. I took the microphone. My name is William Thomas Whitaker. Most people call me Tom. My father, Earl Whitaker, bought the 42 acres behind Cedar Hollow in 1971. I inherited it after he passed. I have paid taxes on it every year. I am not here to attack families who wanted homes. I am here because those families were offered land that was never legally available. The room went still. Randall, Jenna looked up. One Karen stepped forward. That is your opinion. I opened the folder. No, this is the county record. I held up the first certified page. Parcel 14, current owner, William Thomas Whitaker. Lydia took copies and handed them to the front row, then to the board table. I continued. This is the deed chain. It goes from my father to me. There is no sale to Cedar Hollow, no transfer to the HOA, no transfer to Vale Residential Group. Karen said, that does not address the planned expansion. It does, I said, because a plan does not own land. A murmur went through the room. I pulled out the recorded Cedar Hollow plat. This is the official subdivision plat recorded with the county. Cedar Hollow ends at the drainage ditch. My land is outside that boundary. One of the board members leaned forward to look. Then I placed Karen's brochure on the table beside the official plat. This is the map given to buyers. It wraps Cedar Hollow phase around my land. I looked at the room. These are not the same map. A man in the second row raised his hand. Are you saying our lot numbers are not on land Cedar Hollow owns? Before I could answer, Karen snapped, please hold questions until the end. Lydia said, he may want that answer now. I looked at the man. Yes, that is what the county record shows. The room erupted. Voices rose at once. What? We paid a deposit. Karen, is that true? Preston lifted both hands. Everyone calm down. Preliminary reservations are always subject to approval. That was when Lydia opened her binder. Mr. Vale, thank you for bringing that up. She turned to the crowd. Several reservation agreements contain the phrase, subject to final title clearance. That phrase matters. It means final title had not been confirmed when money was accepted. Karen said, that is standard language. Then, you should have no objection to explaining whether the deposits were held in escrow. The room quieted so fast I could hear rain tapping the windows. Preston looked at Karen. Karen looked at her clipboard. Neither answered. Mark Ellis stood up. We gave you $5,000 for lot 37. Was it escrowed or not? Karen said, funds were processed through the appropriate development channels. That is not an answer, Jenna said. Her voice shook, but she did not sit down. Lydia placed another document on the table. This is the rejected preliminary concept plan from 2006. It is the same old Phase E concept map used in the buyer packet. Karen S. face changed. Just slightly. But I saw it. Lydia read the county note aloud. Phase I cannot proceed without acquisition of Whitaker parcel. No one spoke. Not even Karen. I looked at her. My father refused to sell. I never sold, so tell these families what changed. Karen gripped the edge of the podium. The original developer always intended Intended is not recorded, I said. That line landed harder than I expected. A few people murmured agreement. Then Caleb Price stood from the side wall. He had come in quietly, wearing a county jacket and holding a folder under his arm. Karen saw him and looked alarmed. Caleb cleared his throat. I work in county mapping. I'm not here to represent either private party. But I can confirm the public record. The 2006 Phase I plan was not approved as a recorded plat. It was rejected because Cedar Hollow did not control the Whitaker parcel. Preston said, "This is not a county hearing." Look, Caleb looked at him. No, but county records are still county records. For the first time that night, the room turned fully away from me and toward Karen. Then Lydia called the next name. Ruth Danner. A woman in her late 60s stood near the back. She wore a green cardigan and held a manila envelope. Karen S. mouth opened. Ruth, this is inappropriate. Ruth did not look at her. I served as secretary for the Cedar Hollow HOA board for 6 years, she said. There was no valid vote authorizing Mrs. Mills to market or reserve Phase A lots. There was no quorum, no motion, no vote count, no approved minutes. One of the board members behind Karen whispered Ruth. She turned toward him. You know it as true, Dennis. The second board member stared at the floor. Ruth handed Lydia the envelope. I kept draft notes because I was uncomfortable with how this was being handled. Karen S. voice sharpened. You're resigned. You no longer speak for this board. No, Ruth said, but I can speak to what happened while I was secretary. The room broke open again. Buyers stood. Homeowners demanded answers. Someone near the back said, "Did we just get scammed?" Another said, "Where is our money?" Preston moved toward the exit. Lydia noticed. Mr. Vale, I would advise you not to leave before these families receive instructions on preserving their documents. He stopped, jaw tight. Then the clubhouse doors opened, and Marisa Holt stepped inside. The title company officer looked uncomfortable, but steady. She walked to Lydia and handed her a sealed envelope. Lydia turned to the room. Holt is a title officer. She is not here to debate. She is here because her office name appeared in marketing materials. With permission, she will confirm one fact. Marisa nodded. Our office declined to issue title insurance for the proposed Phase I lots because the documents submitted did not establish ownership or development authority over the Whitaker parcel. That was communicated in writing. That was the moment Karen lost the room. Not when I showed the deed. Not when Caleb confirmed the rejected plat. Not even when Ruth said there had been no vote. It was when the title company confirmed they had been warned. Jenna slowly turned toward Karen. You knew? Karen said, no one knew anything final. Marisa said, we told you title was not cleared. Karen's face went pale. Preston muttered, this is privileged business communication. Lydia looked at him. Then you can explain that to the court. I stepped back to the microphone one last time. I know some of you came here angry at me. I understand why. You were told I was standing between your family and a home. But I did not take your deposit. I did not draw those lot lines. I did not put my father's land into a brochure. I looked at Mark and Jenna. I am sorry for what was done to you, but I will not apologize for protecting land my family never sold. Nobody clapped. It was not that kind of moment. Instead, the room sat with the truth. Heavy. Uncomfortable. Undeniable. Karen tried to regain control. This meeting is adjourned. But no one moved. The board member stood behind her. No, he said, it isn't he. He turned to Lydia. What happens next? Lydia closed her binder. Tomorrow morning, we file for an emergency injunction. No more marketing, no more access, no more reservation payments. All records preserved, all funds accounted for. Then she looked at Karen and Preston. And if one document disappears, that becomes its own problem. Karen's hand moved quickly to the Phase I binder on the podium. It was the same binder she had opened so proudly at the beginning of the meeting, the one with the glossy maps, buyer sheets, and Cedar Hollow logo stamped across the front. For 1 second, I thought she was only trying to gather her things. Then, the HOA attorney, who had been silent most of the night, stood from the side table. Leave it there, Karen. The room went still again. Karen froze with her fingers on the binder rings. The attorney's voice stayed low, but every person in the clubhouse heard him. That is now part of the record. Karen looked at him like he had slapped her. I am the board president. Not for this purpose, he said. Not anymore. But she slowly removed her hand from the binder. No one shouted. No one laughed. No one needed to. The woman who had walked in with a clipboard, a microphone, and 96 futures for sale was now being told by her own attorney not to touch the paperwork. Karen walked into that clubhouse as the woman who controlled the room. But by the time the meeting ended, the families she thought would pressure me were standing in line to give Lydia copies of their receipts. By 9 o'clock the next morning, Cedar Hollow phase was frozen. Lydia filed for emergency injunctive relief before the courthouse had finished its first pot of coffee. By noon, the judge had reviewed the certified county records, the rejected plat, the title company letter, Ruth Danner's statement, and the reservation agreements buyers had handed over after the meeting. The order was temporary, but it was enough. No more marketing. No more buyer tours. No more survey stakes. No more equipment on Whitaker land. No more reservation money collected for Phase I. Most important of all, no destruction, alteration, or removal of records by Cedar Hollow HOA, Vale Residential Group, Karen Mills, or anyone acting on their behalf. When Lydia called to tell me, I was standing at my kitchen sink, watching rain run down the window. It's not over, she said, but they can keep pretending now. For the first time in days, I breathed all the way in. The next week was not dramatic in the way movies make it dramatic. No one was dragged out in handcuffs. No sirens came screaming down the street. Karen did not confess into a microphone. Real consequences moved slower than that. They came in certified letters, emergency board minutes, attorney emails, refund demands, insurance notices, and people who suddenly stopped answering phone calls. The Cedar Hollow board suspended all Phase I activity, pending legal review. Then they suspended Karen's authority to sign notices, development letters, buyer communications, or anything involving land expansion. Her name came off the HOA website by Friday afternoon. That was the first public crack. The second came from the buyers. Jenna and Mark Ellis organized a group email with more than 40 families who had paid reservation deposits. Some had paid $5,000. A few had paid more for priority lot selection. They were angry, but now they were angry at the right people. They wanted their money back. They wanted to know whether deposits had been escrowed. They wanted every email, every receipt, every promise Karen and Preston had made. Lydia told them to preserve everything. Not because they were my enemies, but because they were witnesses. That mattered to me. I had spent those first days feeling like 96 families were standing against me. But by the end of the second week, I understood something Karen had counted on me never seeing. She had used them the same way she used the map. As cover. If I looked cruel, she looked reasonable. If I defended my land, she called me selfish. If buyers shouted at me, nobody asked why she had taken their money before title cleared. But once the records came out, the shape of the lie changed. People stopped asking why I was blocking homes. They started asking who sold land they did not own. 2 weeks after the clubhouse meeting, Cedar Hollow held an emergency board session. This time, Ruth Danner was there. So were 3 attorneys, a court reporter, and so many homeowners the fire marshal made people stand in the hallway. Karen sat at the front table without her clipboard. I almost did not recognize her without it. The HOA attorney spoke first. His voice was careful, the way lawyers sound when every word has insurance behind it. The association acknowledges that Cedar Hollow Phase DE was marketed without recorded ownership, annexation, or development authority over the Whitaker parcel. No one cheered. They listened. It continued. The association further acknowledges that no valid board vote authorized the collection of reservation deposits for lots located on parcel 14B. Karen stared at the table. A board member made the motion to remove her as president. Another seconded it. The vote was unanimous. Karen stood before the result was even finished and walked out through the side door. Ron, no speech, no apology, no final threat. Just the sound of the door closing behind a woman who had mistaken control for ownership. Preston Vale did not disappear as easily. Vale Residential Group entered settlement talks after the title company's letter became part of the court record. The State Real Estate Commission opened an inquiry into how the lots had been marketed. Buyers filed claims for refunds. The court ordered accounting of all Phase I funds. Some of the money was returned quickly. Some was not. That part hurt to watch. But this time, Karen and Preston could not make the money disappear into vague development channels. Lydia pushed for a court-supervised accounting of every phase dollar collected. The judge ordered Vale Residential Group to identify every deposit, every transfer, every account used, and every family who had paid for a lot that was never legally available. That accounting became the beginning of the refund process. The remaining deposit account was frozen first. Then Cedar Hollow S insurance carrier opened a claim because HOA letterhead and Karen S title had been used in the marketing packet. Vale Residential Group was forced into a settlement fund for buyer refunds, legal costs, and documented damages. It did not make every family whole overnight. Real life rarely works that cleanly. But it meant Karen and Preston could not quietly walk away while the buyers fought each other for scraps. Jenna told me one afternoon that she and Mark had put off replacing their car because the deposit was supposed to be the beginning of their home. I blamed you at first, she said. I know. Whiningly, I'm sorry. I looked toward the old oak tree. You were told a story, so was everyone else. She handed me a folded note before she left. I opened it later. Thank you for not blaming us back. I kept that note in the deed box. The final settlement did not make me rich in the way people imagine. This was not one of those endings where a judge bangs a gavel and somebody hands you a suitcase full of money. But it made the truth official. Vale Residential Group paid for the damage done to the land, the gravel dumped over the old wagon path, the survey stakes, the painted trees, the ruts from equipment, and the attorney fees tied to stopping the unauthorized development. Cedar Hollow S insurer covered part of the claim. The HOA had to issue a written correction to every buyer and homeowner who received the Phase E packet. Karen had to sign that correction too. Not because she suddenly became honest, because the settlement required it. Her signature appeared under a paragraph admitting that Cedar Hollow Phase I had been marketed without recorded ownership, without valid annexation, and without authority from the Whitaker family. I looked at that letter for a long time. It was not an apology from the heart, but it was an apology on paper. In paper was where Karen had tried to beat me. So paper was where she lost. The county planning office placed a notice in the file for parcel 14B. No Cedar Hollow expansion, access, subdivision, or development application may proceed without written authorization from the recorded owner. My name was on that line. William Thomas Whitaker. After that, Cedar Hollow changed its rules. No expansion materials without recorded deed proof. No development discussions without published minutes. No board president could sign land-related documents alone. No buyer deposit could be accepted without written title review. No executive session could be used to hide a vote that affected homeowners. And no HOA officer could use Cedar Hollow letterhead for any development project without review by the association attorney and 2 other board members. It was not perfect. Nothing with an HOA ever is. But it was better than it had been. On a cool morning in early spring, Emily and I went back to the land together. The orange flags were gone. The glossy sign had been removed. The muddy tire marks were fading under new grass. The pink X was still on the old oak. I hated that. Emily brought a bucket, a brush, and some cleaner from her garage. We worked on that mark for nearly an hour. It did not come off completely, but it faded enough that you had to know where to look. She would have planted the pecans right over there, Emily said. I nodded. Your mother always did know where things belonged. We walked the boundary afterward, just like my father had walked it with me. At the corner pin, Emily crouched and brushed away leaves until the iron showed through. Grandpa really kept all this safe, she said. I looked at the line, then back toward Cedar Hollow. He started it. At the gate, I replaced my father's weathered sign with a new one. I kept his old sign, of course. I could never throw it away. The new sign was simple. Whitaker family land. Recorded 1971. Not for sale. I stood there for a long time after Emily left. Karen had tried to sell my father's land with a brochure, a fake sense of authority, and enough pressure to make honest people doubt what they knew. But my father had kept the deed. I had kept the tax receipts. The county had kept the record. And in the end, that was enough. I did not beat Karen by shouting louder. I beat her by keeping every piece of paper she hoped nobody would read. If an HOA, a developer, or a neighbor ever tried to claim something that belonged to your family, what would you do? Would you settle quietly, or would you make them prove every word on paper? Tell your story in the comments. And if you believe private property should stay private until the owner says otherwise, subscribe for the next property line justice story.